Well, we're going to go ahead and get the meeting started. I want to welcome everyone to the September 17th Municipal Committee meeting. We're starting at, what time is it? 6:03. We have one member that isn't present yet. Hopefully they will be here soon. I would ask that everyone please turn their cell phones off if you haven't done that already. And first item on the agenda is a roll call, and our Assistant City Administrator has graciously said she would do this, so I appreciate it. Missy Wilson, would you please call the roll?
Yes, sir. Alderman Van Buskert.
Present.
Alderman Emerson.
Here.
Alderman Walters. Alderman Azier.
Here.
Alderman Ward.
Here. Thank you. First item on the agenda is approval of the May 21st, 2019 minutes. Hopefully everyone has had an opportunity to take a look at those. And would anyone like to make a motion to approve the minutes from the May 21st meeting?
I would make that motion.
Second.
Okay. Motion by Alderman Emerson, second by Alderman Azier.
Alderman Azier.
Yep.
Alderman Emerson.
Yes.
Alderman Van Buskert.
Yes.
Alderman Ward.
Yes.
Thank you.
Next item on the agenda is consideration of proposed changes to the city's code, Division 2, Controlled Substances and Alcohol. And we have Missy with us tonight. We have Chief Hudspeth, and we have an attorney from Labor Law Firm. Yeah, Labor. Did I get the name right? And that's Julian?
Yep, correct.
And what's the last name again?
Partner.
Hartner. Yeah, see, I forgot that already. Thank you for joining us this evening. And I will just say a couple things. What we can do this evening, or should do, is take a look at the proposed changes in these ordinances related to the criminality of most of it's related to criminality of marijuana versus what is there now, and we have to make those changes relative to changes in the Missouri Constitution and Missouri statutes. So we can do a couple of things after we look at all these. If we agree that the proposed changes are correct, then we can make a motion to just move that to the full board with recommendation for approval. Or if we feel that as a committee we want to make amendments to any of those, we can do that as well. So hopefully all of you have had an opportunity to look through all of those changes, and it's pretty extensive, but I will turn it over to, who do I need to turn it over to first? Who would like to speak first?
I'll just kind of jump in and get some.
Okay, and certainly both of you can take the floor as you need to, or any of you.
Did? Oh. Okay, there we go. Okay. Ms. Hartner and I have worked on this for several months now. She, correct me if I'm wrong on any of this, but she's acting in the consultant capacity for several municipalities that are making these adaptations. So we've been back and forth with, trying to make our ordinances match the change, basically a lot of the state statutes. That's what a lot of these changes are, is just to mirror those state statutes. Several of these things that come when it comes to the enforcement aspects are untested, frankly. I don't know how relevant that discussion is tonight. I'm happy to field any questions you might have about it. We think there's going to be a lot of case law over the next several years as these changes, both at the state level and as they trickle out at the city level, that there'll be some case law. These things will be tested in appeals and through the procedural process. But for tonight, I'm going to leave most of the description of what you see, why you see it the way you see it, to Ms. Hartner, because she's done most of that, or all of that background This has been her sole job for quite some time, right? So she's going to have a lot of background on exactly why it's said the way it is. This has gone back and forth a couple of times, and there are some decision points in here for us to make as a group as well.
And I would hope that both of you would feel free to enter into the conversation if you feel you have something to add or reasons why this has to be the way it is. If we could pause for just a moment, I need to go retrieve my reading glasses because this is not in older adult type. Give me just a second.
Tactical timeout. Some of this will just have to be speaking for Ross and Tracy.
I looked through his comments and
Nothing crazy.
no, I think a lot of it is going to be his call. So.
Thank you. Please continue.
Okay, last little bit, real quick. We have been in contact with the city prosecutor and municipal judge as well. A lot of these changes will affect cases going forward. What we certainly don't want to do is make a decision here tonight that complicates future cases at even our municipal level, because then they'll get appealed to the state level and so on and so forth. So we're trying to be, straight and narrow as we can here and identify things that may create problems for us later. But there's still some decisions to be made there, which Ms. Hartner can elaborate on much more succinctly than I probably. So feel free.
Thank you. So just to give you a little bit of background on the medical marijuana and kind of how it's been evolving. So the amendment was passed last November, and then the amendment designated the Missouri Department of Health and Senior Services as having the authority to regulate. The DHSS, they issued rules a few months ago, and they're emergency rules. So they will be in effect until the end of February 2020. At that point, hopefully we get final rules. I'm not sure what's going to change, but just something to keep in mind that these are things that we're going to be adjusting and probably making amendments to even long after we've passed, final ordinances, because it is evolving. To kind of go into the changes that I made to...
No, sir.
So just...
Oh, I could do it, I guess. No.
So I believe you guys have the red line in front of you, and I know it looks really red. What I did just initially was I pulled out a lot of the definitions that were kind of dispersed throughout and just put them into a single first section definition section. So that's what a lot of the red is really, is that I just pulled definitions that went into each section into a general, so they're easily found. I also updated those definitions to match what the state has put out as the definitions in Chapter 195, the Narcotic Drug Act. So that's where the majority of these definitions come from. There are a few definitions that are medical marijuana specific. So to kind of go to those on, I don't have page numbers? Okay, we don't have page numbers.
If you have it numbered, you might want to go through and number them real quickly.
Sure.
And there's a page on the back for each one, too, just so we can reference those. I think there's 14.
I may have already gotten mine out of order. So.
14 pages, basically.
So I think it's page 5, starting with medical marijuana, that definition. So medical marijuana under the amendment as well as DHSS rules, it matches the definition of marijuana that is also laid out in Chapter 195. So we have that definition of just regular, plain medical or marijuana definition. I added in a medical marijuana to just sort of make a differentiation because we do reference medical marijuana throughout the other sections. It essentially just points you back to the definition given by Amendment 2 as well as DHSS rules and specifies that it is marijuana used in accordance to those two authorities. The next definition I added in that is not part of the Narcotic Drug Act is medical marijuana facility. This is also a definition that doesn't come straight from Amendment 2 or DHSS, but is sort of made to encompass the definitions they give. They break it down into each of the different types of medical marijuana facilities. So there's 5. We don't really get into those in this, section. That's going to be more in your zoning or a general medical marijuana ordinance. So this would just collectively kind of gathers them all under a general term of medical marijuana facility. I did want to just make a note. There is a typo at the last sentence. It should be 10 CSR 30-95. Sorry, it is 10. It should be 19 CSR. That was just one little note. And if you have questions about any of these, feel free to.
If any of you have questions, please put your light on. I believe Alderman Ward has his on. Go ahead, sir.
Thank you. Generally, it appears to me that we haven't made a lot of substantive changes. We've basically tried to make our city ordinances fit with the new constitutional amendment. And so, largely speaking, I don't have any sort of strong objections to what's done here. I do have a few questions and that I'd like to get through and just kind of try and get a better understanding. So looking at the page 1 when we're in section 28.330 and the definition sections, there's when we're talking about the definition of drug. So I would make 2 points to this. First of all, we define the term drug, but we don't really use that term unmodified throughout this document unless we're talking about the Food and Drug Administration or maybe when we talk about that might be it. In the warehouseman and prescription section, there's some use of the unmodified term drug, but otherwise it's always a drug, dangerous drug or drug paraphernalia. And so I'm not really sure what that definition is doing there. But more importantly, when we look at the definitions, these all seem to be in the alternative. They don't seem to be conjunctive. And so we're talking about substances intended for the use in mitigation, treatment, or prevention of disease in any human and animals, or substances other than food intended to affect the structure or function of any body of human or animals. Well, that would seem to include everything from chicken noodle soup to toothpaste. And so we've just defined those as drugs, and I don't understand what the purpose is. So I'll let you answer that first before I go on to my next.
Sure. So that definition is pulled straight from the state statute of how they define drug under the Narcotic Act in Chapter 195.
And there's no other context there that says as listed in Schedule something or another of federal CSR because?
Your controlled substance kind of references that, but no, that is exactly how that definition reads under state statute.
Okay, but we don't intend it to apply to chicken noodle soup and toothpaste, correct?
I don't expect so.
Okay, all right, just I wanted to make, sure. Let's see. Going to page 4, as I believe it is, it's little p. It's the section that says the remaining provisions of this section notwithstanding. And so this is just kind of, I want you to walk me through this, because anytime notwithstanding is used in a statute or an ordinance, it's a pretty powerful word. It tends to undo, perhaps advertently or inadvertently, other provisions we might care about. So first of all, what are we notwithstanding here, and what are the remaining provisions of this section?
So, and I apologize, I missed this. This is one that we added in, that little p. So this is under the definition of drug paraphernalia. Drug paraphernalia goes on for quite a bit. It's a pretty extensive definition. The purpose of the little subsection P is to essentially, well, let me back up. So as I kind of mentioned earlier, state statutes have not been updated to account for medical marijuana. Under current state statutes, there are no exceptions for drug paraphernalia used with medical marijuana.
Except for the constitutional amendment.
Correct,
Right.
but our statutes haven't been updated.
Right.
So yes, under the amendment, there are provisions permitting the use of drug paraphernalia with
Right.
medical marijuana. This is an attempt to sort of reconcile that. So we have used the definition of drug paraphernalia that is laid out in statute. However, we're our goal with the addition of
No, and
subsection P is to create an exception.
And that's great, but what provisions are remaining? It's the last part of that section. I mean, then you go to imitation-controlled substances. So what's remaining?
I think
Should it
the
be a
intention-
foregoing or the preceding or
Yeah, I can revise that if you,
make it A instead of P? I don't know. I mean,
Okay.
I'm just asking. I mean, because I don't understand what provisions are remaining in that section when it appears to be the last part of that section, so.
okay. The intention is for it to apply to,
And I support that. I mean, I think that's great, so.
okay.
Going next to page 5, I believe is where that is. I'd have to scroll through my notes, but it's a general question. At several times, it appears that we have defined growing marijuana as both producing and manufacturing, and it would seem like it can't be both, but we've defined it that way.
Again, manufacture, the definition for manufacture and production are pulled straight from Chapter 195, how the statute defines those two terms. Typically with, when you look at the amendment or DHSS rules, they kind of use manufacture, produce, cultivate in terms of medical marijuana. I have not added in any language
Okay.
in terms of that. That's something that would be better addressed under, a general ordinance for the city implementing.
That's fair. I just, I don't know the background on this and where
Sure.
you got the language. So, I mean, if it's a error in the state law, I mean, it's, we can't fix that, so.
Yeah, those are pulled straight from the statute.
Okay. And when we talk about manufacturing marijuana products, one of them is dealing with extraction. I'm trying to think, I think this is on page 6.
You said for manufacture?
Let's see, I'm trying to. Now, there was something that was talking in here about,
Extraction and chemical synthesis.
is that where it is? But I mean, this is, again, is this from the state law? I mean, is this,
Is it a definition?
well, I got my pages all turned around here, but, I mean,
Okay.
the essential question I had is it sounded like that even somebody that was doing something non-dangerous, they weren't using butane, they weren't using a high-pressure system, they put their marijuana in a vodka bottle, that would be in violation of this law, but,
No, if it's the definition of manufacture where it says, let's see,
or by a combination of extraction and
yes.
chemical synthesis.
again, that's the definition
Okay.
straight
It's
from the
just-
statute.
Perfect. On page 8, you have a section entitled paraphernalia, but I don't know if maybe we need a new title there.
I don't believe so. I mean, that is what the amendment and DHSS refers to. They haven't changed that terminology.
Well, there's nothing in this section dealing with paraphernalia in 28.332, is there? Is this an ordinance
In
section? Or,
332?
I mean, unless it's just, again, the pagination that's off, but the only language here,
It's drug paraphernalia is referred to twice.
I guess it's.
Section A and
But
then
it's
in
also
section-
plant,
section B.
propagate, cultivate. I mean, it's not really the gist of that section. So that was just a question.
Well, I think they're both in referring to paraphernalia used in those, to propagate, to plant, to cultivate. It would be the use of paraphernalia in those means.
So that's planting paraphernalia, not smoking paraphernalia, or,
Yeah, it would cover any paraphernalia that is used either with the use of medical marijuana or the cultivation and
well,
manufacture.
it's to use or to possess with the intent to use drug paraphernalia to plant, propagate, cultivate, grow, harvest, manufacture, compound, convert, produce, process, prepare, test, analyze, pack, repack, store, contain, conceal, inject, ingest, inhale, or otherwise introduce, so.
Pretty much everything.
Yep.
Yeah, okay, I guess I read that more as the growing, harvesting, manufacturing, compounding, converting, okay. And really, I guess we're getting to my last issue, which I think is probably page 10, does that sound right? Are there 11 pages, or,
There are
I
14.
believe there's 14.
yeah, 11, so maybe it's 28,338.
338? Okay.
And
Failure
339,
to
and
produce.
339, I guess, so I'll start with 339, I guess I had two more small.
That's
parts.
on page 13.
Okay. 339, I guess the only question here is, given that there's really not going to be any feasible way for us to detect whether or not somebody is, quote, administering marijuana in like an edible form. Yeah, I get that. But I mean, so I guess one question I have, would we want to break this down into two provisions and have perhaps maybe a relatively minor punishment for the edible administration versus in having a stricter penalty for the smoking administration, because that's probably going to offend people more than if somebody's popping a gummy bear in their mouth. And so I just put that forward as a question. And quite frankly, I'm not even sure I'm all that concerned about having an ordinance against administering a gummy bear. But I understand why people don't want this being smoked in public, so.
Sure, we posed that same question to the prosecutor, and he said it's best just to leave it as an umbrella, you know. Ingesting is ingesting, rather than trying to make different penalties. That may be one of those things that creates case law down the road, because we're kind of making our own qualifiers there.
Well, I guess part of my concern is, Chief, is I don't necessarily want cops going over and saying, you know, let me see that gummy bear package. I mean, let me see, you know, that brownie package, because, you know, the problem is they're going to get it wrong sometimes. Now, if somebody's smelling something, I think most police officers are probably sufficiently well trained to identify the smell commonly associated with marijuana. But I don't know that they're sufficiently trained or capable of being sufficiently trained to identify one gummy bear from another. I mean,
Well, that's one of the very things that's untested. And when ultimately on a long enough timeline will become case law is, you know, you're right. What's the difference in appearance from one brownie to the next? Well, smoking something, there's that odor. So what would, on legal authority, could they come up and demand to see your brownie? You see what I mean?
right, and so I guess I'm just afraid that if we have that tool in there, there are officers that may want to use it in a maybe more vigorous manner than maybe even the police administration would want it enforced, so.
Well, you know, basically, Mr. Nigro is going to be the guy that's tasked with prosecuting.
Well,
these
that's after
cases.
the fact. That's after the person's had a negative interaction with the police.
Sure.
So I just put that out there for comment. And finally, I'll end with, I really want some sort of mechanism so that somebody that just forgets their papers at home isn't told, by somebody that your papers aren't in order, therefore we're giving you a ticket. I mean, if somebody is in fact licensed to possess this, I don't want them getting a ticket just because they left their card at home. And it's fair enough if that ticket's written up, but there has to be a mechanism for automatically dismissing that once they show up and present it to the prosecutor or the court to show that they in fact had authorization at the time, like we do with insurance and driver's license and other things, so.
And ultimately, that's the purview of the judge to decide whether or not to dismiss something.
Well, it is, but we have the purview as a legislative body here in how we craft the ordinance, and is there a way that we can facilitate that or encourage that through the ordinance we pass?
Well, so you are required under the state rules to carry your qualifying patient or primary care.
But we're not required to expend our resources enforcing that provision.
But this would come down to, you know, prosecutorial
But we're not even
discretion.
required by the constitutional amendment to have that ordinance on the books. I mean, we don't have to have an ordinance that says we can fine you if you don't have your card. The state constitution authorizes us to have that ordinance, but there's nothing that's compelling us to have that ordinance, is there?
No, you are not required to have an ordinance
Right.
for this. However, your law enforcement needs a mechanism by which they can determine whether someone is lawfully carrying medical marijuana.
And I'm fine with that, and I'm fine with that. But what I'm saying is I don't want somebody I don't want the 80-year-old great-grandmother who left her card at home getting a $100 ticket because she just happened to forget her papers.
And I don't think that's any intention that a prosecutor has. However, I do feel that it is important for the city to have an ordinance that would allow them to
I agree
write
with
that
that.
ticket.
I agree with that. But all I'm asking for is that perhaps we consider that there's some mechanism that we can, by which we can encourage that decision of the prosecutor. We have a great prosecutor right now. I don't know who's going to be our prosecutor in 10 years from now. I'd just like to have some sort of mechanism where we can say that's, you know, we want this we want it to be a valuable tool, but we don't want it abused.
And I just don't know that that's something you put in an ordinance. You can't limit what your prosecutor,
Well, sure
their
we can.
decision-making.
We can constrain the decision he can make.
I guess, how would you constrain it?
Well, that's what I'm looking for legal advice on.
Well, in terms of you might be able to set a limit on a fee, however, it should probably be sufficient to cover court costs, You could do that.
I don't want great-grandmother having to pay court costs because she left her card at home, even though she was truly authorized. I mean, I don't want to be trying to finance the city on the backs of great-grandmothers.
Well, and typically if charges are dismissed, there is no cost
Right.
associated with it. So if your prosecutor decided to dismiss it, there wouldn't be a cost to her.
Right, but
So
you're,
you
but
could
you're,
say-
but you're saying, but we need to have a fine for it, but if the person's not authorized, the fine is illegal possession of marijuana, and that's fine, they write the ticket for that.
But if someone, even if they have a state license, if they don't have it on them when they have medical marijuana on them,
Right.
they do not legally possess it. You are required under the state rules, if you have medical marijuana on your person or you're transporting it, you are required to have your card. Under the state rules.
But you're not facing a prosecution for, say, a felony possession if you had an ounce, which was authorized by your thing. You're subject to the penalty for not having your ID, which is probably an infraction under state law. Is it not the case?
Well, I don't know that. But the problem here is if we don't require, if there's not some enforcement to require the carrying of the card.
I'm not against requiring the card. I just want to make sure that somebody who is in fact truly authorized isn't having to pay a steep fine, and that there's some mechanism for that to be dismissed or substantially reduced when they produce evidence that they were in fact authorized at the time.
I may interject something here. If you're driving without your driver's license, and there's some discretion the officer would have, if grandma's got, a bunch of marijuana in the car and she doesn't have her card with her, and she just went and bought it, she would have had the card to pick it up.
Yeah, I'm just
and
asking this
transport
to
it in
be-
the first place. And these ordinances, by the way, are not etched in stone. We can always come back and adjust them if we need to. But so there's still a distribution of a controlled substance is illegal. The only thing that would make it legal is if you have the proper papers to show that you can have or possess medical marijuana or use it. And if grandma's using it while she's driving, then that's going to be illegal also, because that would be a violation. If you don't have your driver's license and you come to court and you can produce your driver's license and show you have it, the judge is going to take that in consideration. And if grandma comes to court and she produces her medical marijuana card, then the judge probably would dismiss that at that point, and the prosecutor would say, okay, well.
Yeah, I just wanted to
you're
be
legal.
treated the same.
And I don't think there would be a problem. So I don't think we're looking at hypothetical cases that probably aren't going to happen, because grandma probably ain't going to be the one involved most of the time.
You don't know.
The other thing is, well, again, if we feel that our ordinances aren't adequate at some point in time, we can always come back and adjust those if necessary. But I feel those provisions are important for us to have in place. We're going to encounter a lot of problems with this, because a lot of people are going to be under the impression that marijuana is legal now, and they can possess it, they can carry it, they can have it, they can distribute it, and which is not correct. That there's quite a misinterpretation of that, I think, by a lot of people. And so we need to have, our law enforcement people need to have the tools they need to enforce the laws, and our prosecutor and our courts need to have those tools as well. So I think it's important for us. Is there anyone else that has any questions relative to what has been covered thus far?
I think all my questions have been answered.
Okay, all right. Please continue. Did you have any other questions, Alderman Ward?
No, and to summarize, Bill, all I'm asking is that it be treated similar to an insurance card thing. That's all I'm asking for. I'm not asking for any preferential or special, just that we treat it the same way to,
A couple of talking points that may be helpful here. With any medication that's a controlled substance, certain responsibilities exist. If you have a prescription for Oxycontin, let's say, that's heavily abused, you can't carry it in a Ziploc bag in your pocket. It needs to be in the original container. So I kind of liken it to that. There's some rules there they've talked about when the dispensaries actually start dispensing product. The product has to stay in the original container. Those sort of things are still developing. But specific to this card thing, in one of the DHSS conferences that I went to, they talked about establishing a database in which a police officer could actually roadside pull your name up and see if you're licensed or not.
And that's fine, if they can do
It's just not
that.
developed yet. They haven't gotten
Yeah.
that far yet. They're trying to work through so many things in a compressed time frame. It may be in 6 months or a year that these cards are, they've talked about it in a lot of different strategies, letting people print them off at home or no cards at all. You just do it electronically. We just don't know how that's all going to play out until it starts to develop a little more. I've heard all of that directly from DHSS along the way.
And I guess the one last point that you kind of brought up right there is people do need to remember that unlike OxyContin or any sort of drugs that are regulated under federal law, medical marijuana is a state constitutional right. Now, subject to certain limits, obviously, but OxyContin is not a constitutional right in Missouri. Medical marijuana is.
Just a comparison.
Yep, I understand.
Yeah, it is if it's prescribed.
No, it is not. No, it is not prescribed. In fact,
If you have a prescription
no,
from a doctor.
you cannot get a prescription from a doctor for medical marijuana. That would violate federal.
No, I'm not talking about that. I'm talking about other controlled substances.
Absolutely.
Yeah.
Absolutely. And of course, the reason it's not done as a prescription and the way it's done is because of the revenue, the tax revenue coming off of it that they couldn't do if it was done as a prescription. That's the reason there's a difference here. Otherwise, it possibly would be done as a prescription by a doctor. That's why it's not.
Bill, actually, I think that's wrong. I mean, it's because federal law still has it as a Schedule I substance, which means it's not allowed to be prescribed, and any doctor who attempted to prescribe it would lose their prescribing privilege.
It does, but the state's looking at it as a revenue source, and I think we all know that, what that's really about. Please continue.
Okay. Did you have something?
Nope.
Okay. Okay, I think we were on page 6. Yes. So the last two definitions that I would just direct your attention to that do not come from Chapter 195, but are medical marijuana specific, are the definitions of primary caregiver and qualifying patient. Both of those are pulled straight from Amendment 2. So pretty straightforward. So moving into the main section where we really get into the different, offenses, Section 28, 331, controlled substances. So pretty much I just pulled what the city already had and kind of streamlined it into just 3 subsections. At the beginning of each of those subsections, I added the language, except as authorized by Article 14, Section 1 of the Missouri Constitution, essentially to just create that exception for medical marijuana. Any questions?
Alderman Emerson, did you have a question?
Well, I know that it's been very difficult to get all this done because they haven't given you very much time to work on it. I mean, I don't know why they wanted to rush it through. And it's hardship on you guys to get it all together and to figure it out. And I know federal law says, it's illegal, but Missouri can pretty much regulate whatever they wish, correct?
To an extent, the federal government has issued, a couple opinions saying they aren't really pursuing, taking any action against medical marijuana for the states. So I think it's, at this point, they're just not really addressing it. So until the federal government says Missouri can't, Missouri is able to regulate medical marijuana or allow medical marijuana.
As a state, we do have some rights above what the federal government says, correct?
Not necessarily above, but sometimes up to. If there's a conflict, federal government would trump. But so again, just added in some language to create that exception for medical marijuana under controlled substances, because even our statutes, having not been updated, still classify marijuana as a controlled substance. Again, the state constitution would overrule that, but. So the next section, I think, is 28.332. It's on page 8, paraphernalia. Again, similar to the controlled substances, I just pulled what the city already had, made a couple adjustments, and added in that language to create an exception for drug paraphernalia associated with medical marijuana. And then I think,
And paraphernalia, as we pointed out earlier, could mean paraphernalia for cultivating or producing, or paraphernalia for using, either one, right? Okay.
yeah, the amendment, neither the amendment nor DHSS give a definition of what they consider paraphernalia. So it would be anything that you use in conjunction with medical marijuana, whether growing, using, any of that. So I didn't make any changes to some of these sections. They didn't really have anything to do with medical marijuana. I think the next sections where we made any changes were 28 through 38 on page 13. And we've kind of discussed that. The the amendment, does say that qualifying patients and primary caregivers are not subject to criminal or civil liability if they have their card on them. So it is important that they carry the card. As Chief said, DHSS has mentioned having a system where law enforcement can verify whether someone does have a card and doesn't have it on them. And in that case, I would expect an officer.
Yeah.
Unless they had it and was distributing it to people who did not have their card, even though they have a card, then that would be
That's
illegal.
one of the downsides to these things is that without a database, I have a copy right here, it's nothing to alter it and make copies and sell them, you know what I mean? That's one of the things I think we'll see. But I know they do have plans for some more control.
I hope that happens. At some point, that would assist you a lot.
I'm sorry, Mr. Chair, what did the chief have a sample of that said could be?
Oh, it's a sample of a medical marijuana card, which without any way to verify roadside for a police officer, that's a real challenge. And whether or not is this a copied card or is it an original card, we wouldn't have any way of knowing. Now the dispensary would know because they would be able to check your medical records. But for an officer on the side of the road under this system, there's really no way to know if it's legit or not.
I mean, it's going to be a piece of paper like that, or?
Yeah,
Okay, so it's not going to be issued like a driver's license, or?
not at this time.
Not right
no.
now.
Okay.
Now, they talked about, several different ways, and I'm just kind of sharing this. Sending out secure links to patients. They print their own on their home printer. That's probably convenient, but in terms of identifying a real card or a fraudulent one, we really have no way of doing that street side. So there's challenges there that we'll face on the enforcement side, but it sounds like they're working on those, and long-term, we'll have some better solutions.
So what you're saying is it wouldn't have a photo ID attached to it. It'd be like an insurance card concept.
Well, yeah, all it takes is a couple minutes of Photoshop, I can put my name on that thing.
Right.
Now, when they go into a dispensary, presumably, because you have to submit a photo, don't you, when you apply for this?
I guess what I'm describing here is if I buy my product illegally on the street and I modify one of these cards, it becomes a challenge for us to determine whether or not this is legitimately owned medical marijuana or illegally obtained medical marijuana.
Well, it wouldn't be in the original packaging that,
Ideally, yes.
okay.
And it may depend on the amount of the substance
Good.
that the individual would have
Good.
at the
Without
time to
access to a
determine.
database, we're really at the mercy of what's in front of us. And DHSS realizes that from what, discussions and presentations I've heard. And again, they're, like Ms. Emerson talked about, we're all on a compressed timeline here. They've got to get something out, even though it may not be a long-term solution.
Now, when you go to a dispensary, will they see your picture on their computer monitor when somebody?
I don't know the answer to that. I assume you'd have to show a photo ID and your card.
But don't you have to submit a photo with your application?
You do. You do have to submit a photo with your application, which it was always my impression that would go on your ID card. So, but I've seen at least one patient who has her card and it looks exactly like that. So,
But she hasn't been able to go into a store, so we don't know, because they're supposed to track real time, correct? I mean, if you make a purchase, you can't go next door and buy your limit again, right? I mean,
I believe so.
it's the intent
Again,
anyhow.
yeah, we won't know until they start operating, but I believe that's the intent, is that you will have a limit and they will know real time whether you've hit that limit.
Alderman Emerson, you have a question.
Yes, I do. On the paraphernalia, I know some of the smoke shops have some of this paraphernalia. Is there going to be any control over them?
Right now, they sell them as tobacco products.
Mm-hmm.
So, again, one of the things that may be an issue going forward is you buy a tobacco product at one place and medical marijuana at another. Is it medical marijuana paraphernalia or is it tobacco paraphernalia? We don't really know until that gets challenged because it's not something that's statutorily addressed.
Okay, all righty.
That's a good question. It's one of the
That's a
things we
great
talked
question.
about.
Thank you. Go ahead, please.
Section 28-339, we kind of discussed that, just the administration in public. One change that we could make on there is a definition for administer in both public place that we could not just do a cross-reference to, but we could outline in there if that's something we'd want to do. I believe the last two sections, 28-340 is disposal of medical marijuana. The state regulations they have very specific rules about how you dispose of any medical marijuana byproduct, all of that. So, and they're actually very extensive. So I did not include those verbatim. They go on for about a page and a half. So they're pretty detailed. And then the last section is 28-341, driving under the influence of marijuana. And Chief, feel free to jump in. But this is not one that I necessarily expect that the officers would use very often. I am pretty sure most of the offenses are going to fall under what we currently have for driving while impaired, or having that impairment element. However, the amendment is very specific that you are prohibited from driving under the influence of marijuana. They don't define what influence means. There's really no more guidance on it. And without really knowing exactly what we're going to see when everything, is rolling out and people have their IDs and facilities are open, this may be one that is never used. It may be one that when we make an amendment down the road that we get rid of. But at this point, until we really know what we're going to see, it is one that I would think is important to include.
Would that be through a blood test, if that?
Well, that's one of the challenges with medical marijuana is the way the body metabolizes marijuana is so different than alcohol. Mm-hmm. We've had discussions with the prosecutor about this very thing. Because it stays in your system so long, if you had a medical marijuana card, it's almost like an automatic conviction for driving because the standard the test that would be used would show that you had marijuana in your system. So, and that may be 2 or 3 weeks after it's even ingested. The technology is not where it needs to be, frankly, to determine whether or not somebody is chemically under the influence the way you can with alcohol.
It doesn't determine percentages, the
No,
blood
yeah,
test.
it doesn't. I mean, it'll determine percentages, but there's not a standardized metabolic formula like there is with alcohol. Mm-hmm. So I doubt this would ever be used because we're going to be real careful. We don't want a medical marijuana card to turn into an automatic violation of this ordinance. You need to show impairment, just like you would with any other thing, not necessarily just a chemical test.
So you would have them do the street side sobriety type test.
Well, and actually, drug recognition testing is very different than field sobriety testing. It's actually a whole different course of study. They call them drug recognition experts. And it deals more with pupil dilation and these sorts of things versus balance and coordination, the way alcohol affects you. So there's some challenges there that we think every municipality is going to deal with going forward because, again, there's not clearly established case law where there's a load of it on DWIs.
That probably isn't going to change a lot from how you make that determination now, is it?
It's really not. I mean, if you can show impairment, then you're driving while impaired. You may determine that is because of alcohol or because of a prescribed medicine or because of marijuana. It's really the impairment is the prima facie, if you will, of the offense.
How much text would it add to our ordinances if you included the places that public places include under 19 CSR? I'm always in favor of letting citizens know what the law is. I mean, if that's not going to add 6 pages.
No, those are pretty short definitions, and we've done that with other cities. It's just, sort of a preference. So this is just what I started with. We can absolutely add those.
The discussion we had about whether or not to include the definitions versus referencing DHSS is we expect their laws or their regulations to change, which would mean we would have to come back and make repeated changes to ensure we were compliant with those higher regulations, versus just referencing them, and as they change, we would be automatically compliant based on referencing rather than restating.
Also, when this comes before the full board, certainly there would be opportunities, even at that point in time, to make amendments. And it would be as an ordinance, so there would be 2 readings of it, so there would be opportunities to do that. Is that correct, Missy? Or is that correct,
I'm sorry.
Julian? It would come to us as an ordinance, is that correct, to the full board?
Yes,
It'll be, and so there would be two readings.
yes,
Okay.
that is correct.
Very good. Anyone else have any questions? Okay, certainly. Go ahead.
I just want you to know how much we appreciate all the hard work putting this together, because it was a huge task. So thanks much.
Thank you, Chief. Thank you, Julian. Do you have anything else you'd like to add, either one of you or Missy? Do you have anything you want to add?
Well, at this time, I guess I'm looking for direction from the committee if you want to make a motion to send this on to your colleagues with the minor changes that Alderman Ward has noted and fixing some Scrivener errors, or how do you want to proceed with this?
What changes are we talking about specifically?
Well, adding the definition of places, I know, is one thing I noted here. Or are you wanting to leave it with the reference thereof?
Well, I'd like that, but I understand the concern too, so I don't know if there's some way to do some artful drafting such that it says, such as in CSR, which which currently includes these following places, but may be subject to change by the state or something. I mean, just to try and give the public as much notice as possible.
And that's certainly something we can add when it comes to the full board.
Well, I mean, they can even be brought to us. I mean, yeah. Well, so it sounds like you're looking for a motion. I'll make a motion to send this to the full council with the as amended or
Thank you.
whatever.
Okay, seconded by Alderman Azier.
Okay.
Missy, would you please take the roll? Is there any other discussion relative to this before we take the roll? Okay, please
Okay.
take the roll.
Alderman Ward?
Yes.
Alderman Azier?
Yes.
Alderman Walters? Alderman Emerson?
Yes.
And Alderman Van Buskirk?
Yes.
Thank you.
Thank you. I just briefly, before we dismiss the Alderman Azier had an item we wanted to bring before us. You're going to have to make it really quick. If you give you a couple minutes. Okay.
Actually, I'll not ask for discussion on that. What my concern is, when we come back to the board regarding the budget, was a review of the salary that we pay our code enforcement people. I know that when we bring our budget forward, I'm going to ask that there be.
I don't think your microphone's on, Mr. Richard.
Well, we okay now? I'm just going to ask for discussion when we have a discussion on the budget, that we increase the wages of our code enforcement officers. Without going into lengthy discussion tonight, we can talk about it later, maybe at a regular board meeting, but I think roughly what we're paying, we pay our code enforcement officers less than we're paying our school bus drivers. How much is that? I think it's like $14 a raise back here. It's about the level of a Walmart checker. What we're paying our code enforcement officers. And I think it's the reason why we're not keeping enough, our employees long enough. I think at one point we were down 2 because they can't even make enough money to earn a living. And something we need to take a look at before we finalize our budget for this year.
Thank you. And that's certainly something we can look at when the budget comes before the full committee, and we can make amendments to the budget at that point in time if it's necessary to do so.
Mr. Chairman, I'm over here.
Certainly. We're going to have to make it fast.
I'm fast.
We've got the
Don't you
regular
worry.
meeting coming up quick.
I was just going to say, I agree with Mr. Asia that it needs to be looked at, we should look at it, but I really, when we get to that point, let's talk in real numbers and not talk in adjectives, because I don't know what a Walmart shopper or clerk makes, I don't know what other cities pay, and that's what we need to look at.
Certainly, and we'll have an opportunity to discuss that when we get to that point. I'm going to dismiss us so that we can get to our regular council meeting. Thank you all for coming this evening. Julian, Chief, Missy, appreciate your time. Thank you all for.
I have a motion to adjourn. Thank you.
It was Alderman Azier and seconded by Alderman Emerson.
Yes, sir. All in favor?
Aye.
Thank you.
Did you guys say aye?
I think so.
Thank you.